Looks like Ms. Walsh, are you going to be arguing this?
That's correct. Good afternoon, Your Honor.
Good afternoon. I think I see a Jeffrey Lawrence.
Jeffrey-Lawrence, Cowgill, beneficiary.
I think what you meant was more on -idiot sniffer, soon to be homeless. Anyway, hey guys, welcome back to the channel. Today we're diving into a sovereign citizen who makes a very special appearance and manages to lose his entire RV house in the process. And because his arguments drag on longer than his legal understanding, we're sticking to the highlight reel of the plaintiff's case. Let's get into it.
This case involves a defaulted vehicle loan for a recreational travel trailer. Defendants executed and entered into a retail installment contract with the dealer. The last payment made on the loan account was on or about December 28th of 2021. The balance owing to plaintiff is the principal sum of $35,928.21 plus late fees in the amount of $53.88 plus accrued interest in the amount of $1,325.37, while they have submitted many pages of inadmissible hearsay, including excerpts from several books and alleged excerpts of statutes and constitutional provisions and postal tracking information and other materials, documents that appear to have been drafted by defendants themselves that have names like conditional acceptance or bill of exchange or a declaration of the Naturalization Act of July 1779 for Jeffrey L. Cowgill status correction to the land and soil jurisdiction, not Sea Admiralty. They elaborate on the allegations that the credit union rejected payment that defendants allegedly made by submitting a Form 1099-A, like an IRS form, and a promissory note. But those forms of alleged payment are not legal tender, and the credit union was not obligated to accept them as forms of payment. Defendants also argue that they sent a bond coupon in the form of a promissory note to the credit union as an attempted tender of payment under the contract. However, defendants have not submitted any admissible evidence to support that proposition, and even if they had, that is not a valid form of payment. So the plaintiff asks that the court enter the revised proposed order granting summary judgment to plaintiff.
Mr. Cowgill, I did, just so you're aware, I did read through your response and attachments. So if you have, I'd like to hear what argument you have in response to counsel.
Without prejudice, I, Jeffrey-Lawrence, Cowgill, with Teresa-Ann, Cowgill, the beneficiaries, make a special appearance sui juris propria persona under fraud, menace, and duress before fiduciary Basher. This is a SovCit trust action, which you are now a real party in interest to. I'm the living, breathing man on the land and soil.
Alive? Technically, yes. Breathing? Also yes. But any cognitive function that connects those two basic skills? Absolutely not. It's like watching someone operate on life's default settings with the brain permanently set to airplane mode.
The dead entity, all caps, Jeffrey-Lawrence Cowgill, was expatriated, and I, the living man, have an unrebutted UCC-1 lien and security agreement with the all-caps entity, and Gary Basher serves as the entity trustee in a fiduciary capacity. Virginia law further provides to authorize such filing, the debtor must do so in an authenticated record by authenticating or becoming bound as a debtor by a security agreement, or 3, by acquiring collateral. I have supplied that to you, that there's a UCC-1 claim. The plaintiff's agents are outlandish, stating Federal Reserve published documents are hearsay. Statutes and constitutions are admissible under 56B, as it states. The defendant may move with or without supporting affidavits for a summary judgment in such party's favor as to all or any part thereof. Since the plaintiffs have violated RCWs, UCCs, and U.S. codes, among other laws, these laws are fact and admissible per CR 56B. The plaintiff says the conditional acceptance is a nonsensical document, yet it is in Black's Law Dictionary under conditional acceptance. The definition is an engagement to pay the draft or accept the offer on the happening of a condition. A conditional acceptance is in effect a statement that the offeree is willing to enter into a bargain differing from some respects from the proposed or the original offer. The conditional acceptance is therefore in and of itself a counteroffer. We conditionally accepted the offer of the plaintiff, but the plaintiff ignored us, knowing that the conditional acceptance stated acquiescence would void the original contract. The postal tracking combined with the Esquire Scroggins letter is fact and evidence to the plaintiff receiving the bills of exchange that they did not return. The plaintiff's agent, Esquire Bertolino, admitted they received them as well. What qualifications does any of the plaintiff's agents have to declare what is and is not a bill of exchange?
And what qualifications do you actually have to decide what is or isn't an acceptable bill of exchange? And before you even start, no. Being the lead taste tester at the local paint store does not count as professional experience.
Since the plaintiff's agents, the Esquires, lied about the redacting and have submitted affidavits that they are not qualified to submit, how can their words be trusted? They are not bankers, nor is Mr. Howard. What is his qualifications to make such declarations? He looks at a piece of paper, the plaintiff's agents hand him, and he takes it as gold. I have people at work that know federal and state policies and procedures, but they're clueless as to what those policies and procedures are for. How can Mr. Howard be trusted acting as an entity's agent? No offense, lawyers lie all the time. Fact, Agent Howard produced a terrible photocopy that has a signature on it for the dealership that is not on our copy. Who signed the contract? Can the plaintiff's agents prove that an authorized representative for the dealership that is delegated by the plaintiff signed that contract? The plaintiff wants to rely solely on the contract, so let's talk about the contract. Who signed it for the dealership? Why hasn't the plaintiff gotten an affidavit from the dealership? Because they don't know who signed it. Washington rule does state that the photocopy can be used in the original's place unless there's genuine question of the original, and that alone poses a major question. Where is the original? Is the signature on the original more legible? Is there any other evidential factors on the original that can give us the answers to that truth? On the UCC, we did tender for payment bills of exchange, who the plaintiff's agents are not qualified to decide with their opinion what is and is not a bill of exchange. And as for where the bills of exchange are, ask the plaintiff. What did they do with them? They did not send them back. What did they do with them if not monetize them for gain?
I don't know, maybe they tossed them out. But I seriously doubt anyone monetized them, considering the last time I checked, there isn't exactly a booming marketplace for pre-licked windows.
Esquire Bertolino states that the instructions on the 1099-A state tangible property is not included, yet the exact wording is no reporting is required, meaning you don't have to, but you can. It does not say no tangible property, so Esquire Bertolino lied. The plaintiff has violated many UCCs, U.S. codes, not just 12 U.S.C. 5511B2, C codes and definitions on everything that the plaintiff has violated, and I have proven the facts. Why didn't the plaintiff return the documents they say are not bills of exchange with an explanation or dishonor? Why wait and have Esquire type up some bunk letter and still not return those bills of exchange? When you're doing something and you find out that there's fraud or some shenanigans going on, you stop. That would explain why we made payments until we found out that there was fraud. Payments in fiat currency were being made until we discovered the truth and the plaintiff's agents violated laws and codes. All they had to do is return the bills of exchange with dishonor and or validate the debt or answer the conditional acceptance. Instead, they ignored us. That's why we're here.
No, you're here because you and your sister wife sitting next to you decided to purchase an RV that didn't actually belong to you. You made a few payments, then fell down the YouTube rabbit hole of gurus claiming you can erase debt by mailing in a sheet of paper covered in sovereign citizen gibberish. And now, after following that brilliant advice, you're not RV owners, you're mobile and homeless. Does that about sum it up?
The Federal Reserve publications, like Hearing the Truth from the Horse's Mouth, state exactly how banks operate. How is that not fact? The Federal Reserve dictates what the banks can and cannot do. I'd say their publications are not only admissible, but damning to the plaintiff's complaint. As the plaintiff, they have to prove their complaint, and not only are there holes in their contract theory because of the signature, but it begs the question, why are they dismissing the UCC, which all banks and courts are bound to? And why didn't they rebut the UCC one? And as for the Leach Act, I submitted the copy to the court from the plaintiffs behind a sealed financial record. There's no explanation for these agents or their office to be passing around sensitive information that the agents do not need. So they did violate the act. What is their confidential material protocol? Who has seen the documents and where is it stored? How was it sent to the plaintiff's agents? By mail, fax, email? So how can you tell me it was secured when they didn't take the precaution when they send it to me in regular mail, not certified? The plaintiff never asked if they could share our personal information of that magnitude. This alone sets forth facts to either dismiss or send this complaint to trial, so the plaintiff's agents can be questioned. Put the qualified bankers on stand so we can find the truth. The plaintiff's esquires are not qualified to speak on the plaintiff's behalf, and Mr. Howard is not a banker, so neither is he. I sent, and if you use it without prejudice, like I have, a 1099-A can be anything I want. I can write a bill of exchange on a blank piece of paper. It's what they do with it. They didn't send it back with dishonor. They didn't send it back at all. All they said is, well, now we're going to limit how you can and cannot pay. And so they violated the UCC. And with that, I'm done.
Are you sure you're done? Why stop now when you've still got half a bowl of paint chips left to snack on? Anyway, let's get back to the plaintiff's attorney and see how they respond to this masterpiece of courtroom nutrition.
Any brief response?
Thank you, Your Honor. The retail installment contract expressly provides that the borrower the borrower agrees to pay the amount financed and the finance charge in U.S. funds according to the payment schedule below, as explained on section 1 on the back. That's at Exhibit 1, page 2. It's undisputed that the defendants did not do so, that they defaulted under the terms of the contract. They don't dispute that they received the trailer. They don't dispute that they received this loan. They don't dispute that they made payments under this contract. They knew how to make payments under this contract. And they don't deny that they stopped making those monthly payments. There is no genuine issue of material fact that they entered into the contract, that they defaulted under the terms of the loan, and that they owe the amounts set forth in the Howard Declaration. It's, not appropriate for defendants to malign attorneys generally, or my colleague, Ms. Bertolino, in this court, with no evidence, no admissible evidence that would support any of the allegations that defendants have stated here today. There is no demonstration, no allegations, no demonstration of fraud by the credit union or by anyone. There is no, defendants just simply have not created a genuine issue of material fact regarding the credit union's claim for breach of contract or its entitlement to replevin in this case. And that is, those are the plain facts.
So I got one question I have, which is not necessarily germane to my decision. Does your client still have the bills of exchange that were submitted?
That I don't have an answer for you today.
Your Honor, I've asked for them back and they just blatantly ignore me.
All right. Well, when I look through this, there's a lot of interesting interesting theories that are kind of flowing all through this. What it boils down to, from what I gather, and it seems to be undisputed, is you folks went in, you bought a trailer on time, agreeing to make payments of some amount, pay it off. At some point in time, there was an issue arose where you decided to do something different, and then no more payments were made. There were some submissions of bills of exchange as an attempt to make a payment, as well as a 1099 as an attempt to make a payment. I guess my answer to that is those probably would not be something you could walk into Safeway and buy a banana with, because it wouldn't be considered regular money for purposes of buying things in a retail situation.
Wait a minute, Judge. Are you seriously telling me I can't just stroll into my bank and pay off my entire mortgage with a badly written letter, slapped with all rights reserved, and topped off with a red ink mushroom stamp?
They may work in a UCC type thing or something like that. This is simply a consumer contract to buy a trailer and make payments on it. And when you're all done, you get the title. The credit union, it appears without any objection, has a security interest, which is indicated in the title as the legal owner. And I've not heard, I mean, there may be some other claims, but that you may have against them. I'm not making an assessment of that, because even if you did, it would not upset the contract to buy the trailer. So, I mean, you buy the trailer, you got to make the payments, you make the payments, they get the trailer back. So I am going to grant the motion for summary judgment. In doing so, I want to just give you some guidance, sir. What will ultimately happen is they get the trailer back, and then they sell the trailer to somebody else. They apply the funds they get from that against the bill that's still owing. So the more money they get out of that trailer, the less money you end up having a judgment for. Does that make sense? So it's in your best interest not to do anything to the trailer. It's probably in your best interest to hook it up and drive it down to the credit union, because that would save some costs.
Oh yeah, I don't have a truck to do that, so they can come get it.
Oh, okay. I'm just trying to point out it's.
And so my copy of the contract not having a signature from the dealership doesn't matter?
It really doesn't.
And you being the trustee in this case doesn't matter?
Well, I'm not a trustee, sir. I'm a judge.
You are, because I appointed you one.
What is this world coming to when free houses aren't handed out for creative stationery?
As the beneficiary, because I'm not to do that.
Okay, I'm not able to accept that as a Superior Court judge.
What about them just putting out our social security numbers without our say so? Like, they could have completely ruined our credit. Someone could have those numbers and be doing damage to us right now.
So now, apparently, the judge presiding over your case is the trustee of your estate because you just appointed him. I mean, credit for creativity. Declaring the judge your personal trustee to manufacture a conflict of interest would be one hell of a legal maneuver, if that's how the law worked. But it doesn't. Not even close.
Well, if those were passed to the attorneys as part of the collection, then that would be something that would be allowed. If that was sent out beyond that, obviously that's a separate issue. And if in fact that were a claim that were proven, there may be something there. But again, that doesn't affect the contract. Those are all other claims that you may have. And I'm not saying you do or you don't, because I don't know enough about those, even based on all the information that you filed. And I read through all the stuff you filed, because it's what I do when I do my job. So
can we have those forms of payment back?
Can
we order them to return those to us?
Well, I think it's appropriate. If there's some value in them, those should be returned to them.
There's a lot of value in them if they still have them. And if they don't have them, then
what happens if they don't return them?
Well, I guess you'll need to find something else for lunch, because something tells me nobody at that office is going to carefully scrape the melted crayons off your 1099 before tossing it into the special bin. The one shaped exactly like a dumpster and, coincidentally, almost identical to your future living arrangements. Alright guys, that wraps up the video. I honestly don't know why watching these clowns crash and burn in court is so entertaining, but maybe it's because every single one of them is a scammer who keeps losing spectacularly. If you enjoyed laughing at these geniuses with me, hit that like button. If not, feel free to dislike. Either way, drop a comment below and make sure you're subscribed with notifications on so you never miss any of my content.